Thank you, Alison, for speaking with me today about this. So, in recent years, we've seen states move away from the use of financial pretrial release conditions, also referred to as money bail or money bond. And most recently, as of September 2023, financial conditions are not allowed at all in Illinois. New Jersey and New Mexico have generally and greatly limited the use of money, and numerous jurisdictions across the country have made smaller changes in that direction. In places that continue to use financial release conditions, people often ask, what would replace them? So can you talk about what pretrial justice looks like when jurisdictions stop using money?
That's a great question, Spike. Before answering that, I want to give you a sense of what it looks like right now, right? So to talk about what replaces it, let's paint the picture of what it looks like right now. And right now in our current system, money or financial release conditions, they're really used for two different purposes. First, we know that judges use them as an actual condition of release. That is, it's a condition that is put on someone when they are released into the community after being arrested. And the idea is that that money bond incentivizes a person's return to court. So these are the cases where, again, a judge expects the person to afford the bond and then actually get released. So it's used first as a condition of release. In other places, or in same places, judges also use financial release conditions actually as the means to detain someone. So the judge would set a bond at a very high amount with the expectation, really, that the person won't be able to pay it and that they will remain detained during the pretrial period. So that's when you see bonds set at $1 million or $2 million. Judges are doing that primarily for keeping the person detained. They're not thinking that that's an incentive to return. So when you ask what replaces money, we have to look at those two purposes. What would replace it as a condition of release, and what would replace it as a method of detention. As a condition of release, we know from research, as well as really everyone's experience in the field, is that money is not effective as an incentive to reappear. Multiple research studies confirm that secured financial conditions will not improve the court appearance rate. So looking at similarly situated cases, those with a money bond and those without a money bond, people will come back to court at really the same rate, which is generally very, very high. People aren't absconding, they're not failing to appear. And really that's because money is not going to be an incentive. What is going to get people to court is making sure that they have the ability to do so. And again, there are studies that talk to people who are going through the system. And when you talk to people who are directly impacted, what we learn is that people have trouble returning to court when they have transportation issues. They have childcare or family care issues. They might have work or school obligations. Sometimes they actually, just simply forget. So instead of looking to money, a court can be looking to, well, what can I do to help someone return to court? And often in many places, that's going to be assigning the person to pretrial services so that someone is checking in on them, making sure they have a way to court, making sure they have those supportive services that will get them there. The other thing that we know is very effective at people returning to court is simply a reminder from the court. Right? Just like we have reminders for our dental appointments, which I would forget if I didn't have them. It really works the same for court appearances. So simple court reminders. Now that's about the condition of release. So as a method of detention, what we also know is money isn't effective. Putting $1 million on someone isn't a guarantee that the person will be detained. And unfortunately, too many times we hear about a news story when the judges thought that a $50,000 or $100,000 bond would probably keep the person detained, they are able to access money, pay their bond, and get released, even if they are at high risk of, some danger in the community. So what we want to do is to replace money with a system that's more intentional, what's called a preventive detention. And that's an intentional process where the judge is not setting a money bond, but actually making a substantive decision about whether this person can be safely released. I want to also say that the other problem with money, of course, when it's used for a release condition, is that judges often overestimate the amount that someone can pay. So even when they set a low bond at like $5,000, which they might seem is low because maybe it's only a 10% that someone has to pay to actually be released, but people before them do not have the money. Really, any amount of money bond or a financial condition of release could detain that person, even when it's not the judge's intention for them to be detained. So an intentional process, a system of preventive detention, is really something that would get rid of money, and you allow the judges to make real decisions. That often requires legislative change at the state level.
So can you say more and explain about the preventive detention, about a pretrial detention hearing process, and how that enables like the constitutional and transparent detention of people who are potentially dangerous to the community?
We're seeing this actually in real time. It's no longer a theory about what preventive detention would look like, because we see in both Illinois and New Jersey and elsewhere where this is 100% working. It is the operation of every court in these states where they don't use money at all. In these states, the way it works is once someone is arrested and they are scheduled for their first appearance hearing, the prosecutor reviews the case, and they have to first request that the person is detained after that first appearance. So they usually will have to file some sort of motion for detention, and then the court will hold a detention hearing, and it's often called that, a detention hearing. So the names of the hearings even change. A detention hearing is not your typical first appearance hearing, right? Typical first appearance hearings, unfortunately, and if you've seen YouTube videos or other videos of these, sometimes they're just a cattle call of people, right? So the judge lists a name, the person goes up, and the judge says, you've been charged with X, $5,000. I mean, there's no discussion. It's 30 seconds at most. Now that's not everywhere, but in a lot of places. This is very different. This is a detention hearing. Usually this will be maybe later in the day after they were arrested, or a few days later, depending upon the jurisdiction. And that is meant to give, of course, the parties time to prepare. The prosecutor has to prepare a case to demonstrate with evidence why they think this person is a danger to society or a risk of, flight, that they won't come back to court. And they can't just state that as a conclusory statement. They have to demonstrate it with real evidence that is often dictated through the legislation. The law will say this kind of evidence, evidence of prior criminality, evidence of an intention to inflict harm on someone, evidence of a prior pattern of criminal behavior, maybe even a written testimony from a victim that expresses the danger they think will be there if the person's released. And these are not 30-second hearings. These are often 30 minutes, 45 minutes, where the prosecutor has to set their standard. They have to establish in these places that the person is a danger by clear and convincing evidence. And so they first have to present their evidence. The defense is then given a chance to kind of counter that evidence or present other evidence that could dissuade a judge from that. And then the judge must weigh the evidence and make an explicit decision on the record about whether, if they release or detain the person. And then importantly, it even provides a right to appeal for both sides. If they are released, the prosecution has a chance to appeal. If they are detained, the person also, excuse me, also has a chance to appeal that decision.
Can you say something about people who may pose safety risks, but they don't rise to the level of needing to be detained following the detention hearing process?
We know from the data, sort of nationally speaking, that really 80% of people who are released will come back to court and they will not get rearrested on any sort of offense during their pretrial release period. A very small percentage are at risk of that more dangerous crime or more serious crime. And the judge may indeed, right, decide that they should be detained. But for those who there's, some worry, but not an extreme worry, the best thing to do is to make sure you have some sort of support in the community to help the person with whatever is maybe leading them to criminal behavior. And so the best place for that is usually a pretrial services agency. They are structured to be able to meet with someone, to monitor that person, check in with them. Most importantly for pretrial services is really getting to know the person and then trying to connect them with supportive social services that they might need to get their life back on track. The judge is seeing someone in that moment, probably at the very worst moment in that person's life. It is not their everyday normal thing. No one wants to be in that position. It is generally coming from a place of desperation and pain and trauma. And so pretrial services has a special role that before this person even gets sentenced, before they get put into the system in a real way that can lead to more criminal behavior in the future, there's an opportunity early on to really try to understand this person and try to connect them, like I said, with the services they might need. Those might be substance, use treatment. It might be behavioral health or mental health services. It could be just help with getting a job or help with housing. So pretrial services is a really great option for judges when they have some concern, but it doesn't rise to the level of needing to detain them.
Thank you, Alison. That makes a lot of sense. You mentioned legislative change earlier, and these approaches are not the status quo in most places. So what can jurisdictions do to move toward these approaches and what we're talking about?
So I agree, Spike. Abolishing money is very, very difficult. I mean, it's why we haven't seen it in that many places, and it does take an enormous effort. It does require legislative change, generally to change the system and create that preventive detention system. But there still are ways that counties and local systems can take steps to minimize their use of money. And one of the things that we suggest to stakeholders when we're working with them is we really ask them to question their use of money as a release condition, right? Personally, I think jurisdictions tomorrow could really eliminate money in that regard. There is just simply no evidence at all that it helps people return to court. And it doesn't, and of course, there is no evidence that it deters anyone from any dangerous behavior. So you have to ask, why are you putting it on someone as a release condition? If it doesn't serve the two purposes that a release condition is meant to serve, right? To help someone return to court and to deter them from any criminal behavior. it would be as if you were saying, I'm going to put a condition of, we mentioned going to the dentist, I'm going to put a condition of you going to the dentist as your pretrial release. It has no connection to what they're supposed to do. That, to me, it's that illogical. And so I would really ask all judges and prosecutors who are recommending it to really question their use of money and simply stop asking for it. And if the person needs some support, then give them that support by ordering them to pretrial services, looking at other ways to help them get to court, make sure there are court reminders in their system as a whole, make sure that if there's a need for a protective order or a stay away order, that is done. Some places there are electronic monitoring that, again, is not proven to be that effective, but may give some confidence to the judges or the prosecutors that at least there's someone watching over this person. And so really, starting tomorrow, just get rid of money as a condition of release.